Hello students and welcome to the lecture. So students, as we know that we had started the discussion over the fundamental rights, okay, and we had started the discussion over the introduction and then we shifted to the features, okay. So in the previous lecture, basically we had started with the features of the fundamental rights, okay, and basically we had discussed the several features. Like we had discussed that basically they are not absolute but qualified. And what did we mean by this? Basically, we had discussed that the provisions of fundamental rights are not as to be applied at any cost. Basically, the parliament having the power that they could put the restrictions on the provisions in the certain conditions. Thereafter, we had discussed that some of them are exclusive rights, which means only for the citizens. All right, only applicable for the citizens, and some of them are the universal rights, which means that they are applicable for both for citizens as well as foreigners, right? And as we know that originally the constitution has provided the 7 fundamental rights, but later that was the 42nd Amendment Act 1976 that deleted the one of them, right? Wrong. Why? Because in the previous lecture I had told you that was not 42nd but 44th Amendment Act, and the year was not 1976 but the 1978. Okay, so that's the thing. And which act was deleted? Right to property. Okay, and this is later added under Article 300A as an legal right. Thereafter, we had discussed that if any law passed by the legislature and if any action have been taken by the executives to enforce the provisions made under Article 31C, Article 31B and the Article 31A. Okay, then these are basically exempted from the judicial review provisions. Okay, so these are some of the things that we had discussed, okay, in the previous lecture. So it's a little bit a revision of the previous one. Today in this lecture, basically we will continue from where we had left in the previous one. I hope that you have revised the previous lectures in the well enough manner before you have come for this lecture. As many times I have told you that is for your own benefit. Okay, so this point we had discussed, this is also, that is also, and this one also. Okay, thereafter, now we are going to see the important thing which is known as the definition of state. Okay, like whenever I have seen the people, like whenever we talk about state, usually they think of the provinces. Which means that if we talk about India, okay, so we know that India having 28 states or provinces and 9 union territories. Okay, we know this. So many times I have seen people, like whenever the word state comes, so they always start thinking over these. Like basically we are talking about it. But no. Here we had the complete meaning of the state. Like what do we mean? What do we mean by the term using state? So if we go by the lines, the term state has been used in the different provisions concerning the fundamental rights. Like whenever we talk about the fundamental right or anything concerning the fundamental rights, so the state word has been used for the different provinces. It means for different things. Hence, Article 12 has defined the term for the purposes of Part 3. Like in the starting of this series, I had told you basically in the fundamental series there are articles starting from 12 35, right? That is what we had discussed. Okay, so basically if we talk about the Part 3, which deals with the fundamental rights, so Article 12 has a well-defined meaning that which thing or which area we will consider as a state under this particular series. Okay, so according to it, states include these followings. The first thing is the government and the Parliament of India. Okay, which means that the executive and the legislative organs of the union government will be the part of the state. Thereafter, the second is the government and the legislature of states, that is executive and the legislative organs of the state government. Here basically we are talking about the provinces. Thereafter, if we talk about the local authorities like the municipalities, panchayat, district boards, improvement trust, etc., these are also the part of the states. Okay, thereafter all other authorities, that is statutory or non-statutory authorities like the LIC, ONGC, SAL, these all are the part of the states. Okay, so here we can say that 3 levels are directly, which means central level, state level, then comes the local level. Okay, these all are the governmental levels, so that's why what we can say that these are the part of state. Okay, but if we talk about this one, like statutory, non-statutory bodies and all, okay, if they are related with any governmental authority, then basically these are the part of the state. Okay, so that's a thing. Thereafter, thus the state has been defined in a wider sense so as to include all its agencies workable. It is the action of these agencies that can be challenged in the courts as violating the fundamental rights. Why? Because the fundamental rights are specially designed to counter the arbitrary powers of the state. Okay, and here we could see that these all are the part of the state. So if any actions they had taken, whether in the legislative form, and the executive form, these things will be challenged in the court. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of state under Article 12. It means that basically whatever we had seen in the previous lecture, in the previous slides, they were either at the central level, state level, or the local level, or somehow related with these agencies. But if we talk about the private body or an agency which is working in the collaboration with the government, okay, or working with the government through some agreement, so that particular thing will also be considered as a state under Article 12 as per the Supreme Court. Okay, that's the thing. Thereafter, which are the laws which will be considered as an inconsistent with the fundamental rights? What are these? So here Article 13 declares that all laws that are inconsistent with or derogation of any of the fundamental rights shall be void. In other words, it expressively provides for the doctrine of judicial review. Like, which are the laws, which are the acts, which are the legislations which could be taken under the review, judicial review. Okay, what are these? So basically that's from the doctrine of the judicial review. So if we talk about this, so this power has been conferred on the Supreme Court under Article 32 and on High Courts under Article 226. That can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. So we could say that basically the power of judicial review constitutionally or fundamentally vested with the Supreme Court as per the Article 32. Further, it is extended to the High Courts under Article 226. Okay, like by using these powers, they can review the legislation and they could declare it as an unconstitutional and invalid on the grounds of contravention of any fundamental rights. So basically the law term under the Article 13 has been given a wide connotation so as to include the following. The first, the permanent laws enacted by the parliament or the state legislatures. Thereafter, the temporary laws like the ordinances issued by the president or the state governors, as we know, when the parliament, when this is the president, when the state legislature, when this is the governor. Okay, if any of them is not in the session, then basically we know that the president and the governors could pass the ordinances under their ordinance making power, right? That is what we had discussed. Okay, so if any ordinance made by the president or the governor, these could be declared as a law. Thereafter, statutory instruments in the nature of delegated legislation, the executive legislation like order, bylaw, rule, regulation and notification. Thereafter, the non-legislative sources of law, that is custom or uses having the force of law. These will be included as in law under the Article 30. So remember, Article 12 define the state. Article 13 define the law. Okay. Thus, not only a legislation but any of the above can be challenged in the courts as a violating of fundamental rights and hence can be declared as void. It means that not only those legislations which are passed by either the parliament or the state legislature, but also the other things which we had discussed under Article 13, these could be taken as an law and these could be challenged in the court as violating our fundamental rights. Okay, thus they could be declared as an null and void. Further, there is an Article 13 which declares that the constitutional amendment is not a law and hence cannot be challenged. Okay, like here, whatever the four things we had discussed, none of them is an amendment. Okay, so if the amendment is not considered as a law, then basically that could not be challenged for the judicial review. Okay, that will not challenge as a part of judicial review. However, the Supreme Court held in the Keshav Bharti case 1973 that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution. Like in the general sense, we could say the amendment is not considered as a law under the definition of law prescribed by the Article 13. But thereafter, there was a famous case, Keshav Bharti case, which happened in the 1973, in which the Supreme Court said that generally the amendment is not a law so that it could not be put under the judicial review until or unless the amendment has been made in the sense that it violates the basic structure framed by the Constitution. If that is happening, then the amendment even could be challenged in the court, alright, and thus could be declared as a null and void. So that's happened in the Keshav Bharti case 1973. Thereafter, if we talk about the laws inconsistent with the fundamental rights, so we have the first table, okay, which presents the fundamental rights at a glance. Like the first category is the right to equality, which having Article 14 to 18, it means that there are 4 articles basically. So if we talk about it, the first article is equality before law and equal protection of law provided by Article 14. Thereafter, the prohibition of discrimination on the grounds of religion, race, caste, sex, which is also known as gender, or the place of birth under the Article 15. Thereafter, equality of opportunity in matters of the public employment should be provided under Article 16. Thereafter, abolition of untouchability and prohibition of its practice under Article 17, and thus abolition of titles except military and academy, Article 18. So these are the articles of right to equality. Thereafter, if we move forward, we could get the right to freedom prescribed under Articles 19 to 22. So basically, the first is protection of 6 rights regarding the freedom, like the freedom of speech and the expression, freedom of assembly or gathering, freedom of association or cooperation, freedom of movement and travel, freedom of residence, and then the freedom of pursuing profession. Thereafter, these all are provided by the Article 19. Remember this. Thereafter, protection in respect of conviction for the offences under Article 20. Thereafter, protection of life and the personal liberty under Article 21. Thereafter, right to elementary education under Article 21A, and the protection against the arrest and detention in the certain cases under Article 22. Then, if we move forward, there is a right against exploitation. Consider 2 articles from Article 23 to 24. The first is prohibition of trafficking or the traffic in the human beings and the forced labor as per the Article 23. Prohibition of employment of children in factories, etc. under Article 24. Thus, if we move forward, right to freedom of religion under Article 25 to 28. So basically, there is a freedom of conscience and the free profession, practice and the propagation of religion, Article 25. freedom to manage the religious affairs under Article 26, freedom from payment of taxes for promotion of any religion under Article 27, freedom from attending the religious instruction or worship in the certain educational institutions under Article 28. Thus, if you move forward, thereafter the cultural and the educational rights from Article 29 to 30. First is the protection of language, script, culture of minorities under Article 29. Right of minorities to establish and administer the educational institutions under Article 30. Okay. Then there is a right to constitutional remedies under Article 32. So basically this contains the right to move the courts move the Supreme Court, all right, for the enforcement of fundamental rights, including the writs. What do you mean by writs? We will see further. Writs like the habeas corpus, mandamus, prohibition, certiorari, quo warranto. Okay, all are these provided under Article 32. Okay. Thereafter, now basically, as I had told you in the starting, that there are some exclusive rights and there are some universal rights. Okay, so if we talk about it in the detailed form, so basically, first is the fundamental rights available only to citizens and not available to the foreigners, means they belong to the exclusive category. Second ones are the fundamental rights available to the both citizens and the foreigners except the enemy aliens. These are the universal rights. Okay, so the first here in the exclusive right is that prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth under Article 15. Okay. Similarly, if we talk about the universal, so the equality before law and equal protection of laws under Article 14, that is applicable to all and you can say available for all, whether it is an Indian citizen or the foreigner. Thereafter, equality of opportunity in the matters of public employment under Article 16 and protection respect of conviction for offences Article 20. Thereafter, if we talk about others, then there is a protection of 6 rights regarding the speech and expression, regarding the assembly, association, movement, residence, profession and others under Article 19. They are exclusively available for the citizens only. Then protection of life and the personal liberty, that is applicable for both. Thereafter, protection in life and the personal liberty, Article 21. And then the right of minorities to establish and administer education institutions, Article 30. These are the exclusive right. Whereas if we talk about this one, like right to elementary education under Article 21A, which means from 16 to 14 years of age, every child must get the education sponsored by the state. Okay, so this is this. Remember that basically that is provided under the directive principles of state policy. Okay, basically that was provided under this. But then what happened? There is a famous Amendment Act, '86th Amendment Act of 2002. Okay, basically that Amendment Act was passed in the 2002 and transferred the DPSP provision into the fundamental rights. Okay, so that's the thing. Got it? Like if we talk about the DPSP, we know that these are not enforceable and it is totally depend upon the discretionary of the state government, so discretionary of the government. Okay, so that's why to make it enforceable and make it responsibility of the government, basically it was transferred in the fundamental rights. Got it? Thereafter, the protection against the arrest and detention in the certain cases, Article 22, that is applicable for both, whether the Indian citizen or the foreigner. Prohibition of traffic in the human beings and forced labor under Article 23, that is applicable for both. And the prohibition of the employment of children in the factories, etc. under Article 24, that is also applicable for both. Thereafter, right or to freedom of conscience and the free profession, practice and the propagation of religion, Article 25, applicable to both, whether it's a Indian or the foreign citizen. Right to manage the religious affairs under Article 26, that is also applicable for both. Freedom from payment of taxes for promotion of any religion under Article 27, that is also applicable for both. Freedom for attending religious instruction or worship in the certain educational institutions under Article 28, that is also applicable for both. Okay. Now, after finishing this, we are going to talk about the right to equality. Okay, like what do we mean by this? So we know that is basically provided by the Article 14 and thus followed by 15, 16, 17 and 18. Okay, so basically there is the first thing which we could see here is the equality before law and equal protection of law. Okay, equality before law and equal protection of laws. So if we try to find it out, so basically there is an Article 14 which says that the state should not deny to any person the equality before the law or the equal protection of the law within the territory of India. It means that this is also the universal right, as we had just discussed. Like if any person is in India, whether he is a foreigner, whether he is an Indian, if he is under the territory of India, so it is the responsibility of the government that the government should ensure the person must have the opportunity to get the you can say representation as the equality before the law and get the equal protection of law. This provisions confers right on all persons, whether the citizens or the foreigners. That's I had just told you, like this is the universal. Thereafter, moreover, the word person here includes the legal person, statutory corporations, companies, registered society, or any other type of legal person. Which means that if we're talking about persons, we are not only talking about the human being. Okay, basically we are also talking about the artificial person or abstract person. Okay, so these are the legal persons like the statutory corporation, company, registered society, and any type of legal person. Okay, the concept of equality before law is of the British origin, and while accept the equal protection of law. Okay, student, I think that we do not have a sufficient time to start with this right now. Okay, so what we will do that we will basically start the discussion over it in the next lecture. Okay, till then just revise the facts and figures whatsoever we had discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture, and what we say thank you. Okay.